Welcome to the deep dive. Today we're doing something a little different.
Yeah.
Instead of our usual mix of articles, we're diving deep into a really comprehensive document on charitable purpose trusts.
Oh,
It's one made freely available to students by the University of London. So a big thanks to them for that resource,
it's great. Good material.
definitely. And this deep dive, it's really for you, the learner. Maybe you're gearing up for an exam, or perhaps you just want to get a solid grasp of this area of law, or maybe you're just curious.
hmm
Our mission here is basically to unpack this University of London material. We want to pinpoint the key concepts, the important cases, and give you a clear roadmap for studying this topic effectively.
Sounds good. And just to be clear.
Yes, absolutely.
Right.
This discussion is purely for educational purposes. We should make that very clear up front.
Right. And that University of London document, it really is a fantastic starting point. It gives a very structured look at charitable purpose trusts.
So we'll be pulling out the core ideas.
Exactly. Pulling out the core principles, looking at those landmark cases that really shape things, and basically highlighting what you need to focus on to, get your head around this topic.
Think of it as your guide, maybe, to the essentials. We'll cover the definition, that absolutely vital public benefit requirement,
Crucial.
what makes these trusts fail sometimes, and that interesting Cypre doctrine.
Yeah, as near as possible.
Exactly. And importantly, we'll try to give some pointers on studying the key cases, the main concepts you really need to nail down.
Because charity law, it can seem quite intricate, can it? Bit of a maze.
It really can. But if we break it down, focus on the core principles, the big cases, I think we can make it much more manageable.
Definitely. Let's unpack it.
Okay, let's get started then.
Right. So, the University of London material kicks off by looking at charitable status itself.
Mm-hmm.
And it makes a good point straight away. Trusts are a major way charitable goals are achieved, historically, but they're not the only way. You've got charitable corporations too, for instance.
That's important to remember. It's not just trusts. And the really interesting thing is when a trust is set up just for charitable purposes, the normal, often quite strict rules for private trusts they get relaxed.
They do. And why they're relaxed tells you a lot. It really underlines how the law wants to encourage and support charity.
So how does that work in practice? Take the beneficiary principle, for example.
Right, the beneficiary principle. Normally, you need clear beneficiaries who can actually enforce the trust. But with charitable trusts, not really beneficiaries in that sense.
So the people who benefit, like patients in a charity hospital, they can't sue.
No, they can't personally enforce it.
Yeah.
That power lies elsewhere with the Charity Commission and the Attorney General. That's laid out in Section 13 of the Charities Act 2011.
Okay.
And because there aren't beneficiaries in that Saunders v. Vautier sense, that whole principle where beneficiaries can agree to end the trust, it just doesn't apply to charities.
Which makes sense, given charities often aim to exist long-term for the public good. What about certainty of objects? Usually you need to know exactly who benefits.
That's relaxed too. As long as the person setting up the trust, the settler, clearly intended to give to charity, even if they just say for charitable purposes without getting specific,
That's enough.
that's generally valid. The court can then step in and devise a scheme to make sure the money is used properly for charity. It allows for generosity even when the details aren't fully fleshed out.
That flexibility seems key. And then there's the duration. Private trusts generally can't last forever.
But charitable trusts can. They can have perpetual duration.
And if the original purpose becomes, say, impossible or just outdated.
Well, that's where the Cypress doctrine enters the picture. We'll definitely get into the details of that later on.
Okay.
But essentially, it lets the courts redirect the funds to a similar charitable purpose. It keeps the charitable intention going.
Got it. Another difference the material points out is the rule against remoteness of vesting. That sounds technical.
It is a bit. It usually stops property being tied up too far into the future in a trust. But for gifts between charities, this rule doesn't apply.
So you could leave property to charity A and say if they fold, it goes to charity B, no matter when that happens.
Exactly. That gift over to charity B would be valid however far off it might be. That's quite different from how it works with private trusts.
And finally, tax. Charities get tax breaks, right? Reductions, exemptions.
Yes, significant fiscal advantages. And the University of London material brings up that interesting debate. Should these tax benefits actually influence how we define charity in law?
That's a tricky one.
It is. Some argue, maybe not every purpose that fits the definition deserves tax relief. There's talk sometimes about direct grants instead of tax breaks.
But that raises questions about independence.
Exactly. Concerns about independence, potential for more political lobbying. The courts haven't really said definitively that tax status should dictate the definition of charity. It's an ongoing discussion.
So for anyone studying this first part, the main takeaway is really understanding why the rules are relaxed for charitable trusts.
Precisely. It all comes back to enabling and encouraging charitable work for the public good.
Okay, let's move on to the meaning of charity itself. The University of London document talks about a crucial two-stage test.
Absolutely. This is fundamental. Section 2.1 of the Charities Act 2011 puts it into law. Two questions. One, is the purpose prima facie charitable? Basically, does it look like a charity on the face of it?
Okay.
And two, is that purpose for the public benefit? Both need a yes for the trust to be charitable. You absolutely have to remember that two-stage test.
Let's take the first part then. Prima facie charitable. The material mentions the old statute of charitable uses 1601 preamble. Why is that still relevant if it's old law?
Historically, it's hugely significant. For centuries, that preamble was the list. It set the benchmark. Then, much later, you get Lord MacNaughton in the famous case Income Tax Commissioners v. Pemsel in 1891.
Pemsel, right.
Right.
A key case.
Absolutely key. He derived four main categories from that old preamble, and they're still incredibly influential. 1, relief of poverty. 2, advancement of education. 3, advancement of religion. And 4, other purposes beneficial to the community within the spirit and intent of the preamble.
You have to know those 4 Pemsel categories.
You really do. They're the foundation.
That fourth category, though, other purposes beneficial to the community within the spirit of the preamble, always seemed a bit, well, vague.
It was. It was the trickiest one to apply. It wasn't enough just to be beneficial. It had to link back somehow to the kinds of things listed way back in 1601. The Williams Trustees VIRC case from 1947 shows how difficult that could be.
So how did the law clarify that?
Well, that's where the Charities Act 2011 comes in again. Section 3.1 gives us a much more detailed list, 13 specific heads of charity. It builds directly on Pemsel, but gives much more clarity.
13 heads. That's quite a jump from 4. Can you run through them quickly, just the main areas?
Sure. Section 3.1 lists things like A, prevention or relief of poverty, B, advancement of education, C, advancement of religion, D, health or saving lives, E, citizenship or community development, F, arts, culture, heritage, science, G, amateur sport, H, human rights, conflict resolution, equality, I, environment, J, relief of need, youth, age, ill health, etc., K, animal welfare, efficiency of armed forces or emergency services.
And the last.
And basically, anything else already recognized as charitable or analogous to the other heads. It's a kind of catch-all ensuring flexibility.
That last one sounds like it keeps the door open a bit, like that old 4th category in Pemsel.
Exactly. It allows the law to adapt and recognize new beneficial purposes that fit the overall charitable framework.
Okay, maybe we could look at a few of those heads in a bit more detail based on the University of London material, starting with poverty.
Right. Prevention or relief of poverty. Yeah. Key thing here, the beneficiaries need to actually be poor, not necessarily destitute, but lacking essentials for a modest life.
And the cases. Rhys Scarisbrooke. Rhys Sanders.
Crucial cases. Rhys Scarisbrooke from 1951 said a trust for one's own poor relations could be charitable. But Rhys Sanders W.T. in 1954 held that a trust just for the working classes wasn't charitable, because not all working class people are legally poor. That distinction is vital.
And the 2011 Act added prevention of poverty, too.
Yes, prevention was added, focusing on root causes. That came up in the Charity Commission v. AG case in 2012. The University of London material also flags Ray Niazi's W.T. from 1978, a hostel for working men, as being really borderline, showing how context matters.
Okay. How about the advancement of education? Sounds broader than just schools.
Much broader. It covers research like law reporting and the Incorporated Council of Law Reporting case, promoting arts like the Royal Choral Society, museums like the British Museum Trustees, even school sports facilities, as in Ray Marriott.
But not politics disguised as education.
No, the courts watch for that. Rhys Hopkinson is the case there. But, importantly, education about politically controversial topics can still be charitable. Rhys Coupler W.T. shows that.
And research can be tricky.
Yes. Rhys Shaw and Rhys Hopkins's W.T. are examples where the courts questioned if the proposed research actually provided enough public benefit to qualify as educational charity. It's not automatic.
Moving to advancement of religion, the law has to be neutral here, right?
Completely neutral between different faiths. Neville Estates Ltd v. Madden makes that clear. But it has to be religion. Promoting just ethics or morals without a spiritual belief doesn't count. That was South Place Ethical Society.
And the 2011 Act updated the definition.
It did. Section 3.2 now explicitly includes belief in more than one God or belief in no God. The Scientology case, Hodkin, is often mentioned here, but the University of London material rightly notes that was about registering a place of worship, not strictly charity law itself.
So even if it's a religion, it still needs public benefit.
Absolutely. That's always the second stage of the test.
Okay, and that last pencil category, other purposes beneficial to the community, how does that map onto the 2011 Act?
It's essentially expanded and clarified into those later heads in Section 3.1, things like D, health, E, citizenship, right through to Sakantramal. Under PEMSL, you always have that tricky need to link back to the 1601 statute Spirit AGV National Provincial Bank. Emphasize that.
So the 2011 Act makes it clearer.
Much clearer. It explicitly lists things like disaster relief, North Devon case, although the benefit still needs to fit ahead. Sport on its own generally isn't charitable, nottage, but Section 5 now covers public recreational facilities specifically. And now we have explicit mention of advancing citizenship, human rights, animal welfare.
And the material asks if older cases like Williams Trustees or McGovern might be decided differently now.
It's a good question to ponder. Would their purposes fit more easily into these newer specific heads like human rights or citizenship? It's something to think about when studying.
So for students again, memorize Pencil's 4 categories, understand how the 2011 Act's 13 heads expand on them, and really dig into those case examples for the nuances.
Exactly. And remember, fitting into a category is only stage 1. The purpose must actually confer a benefit.
Right, it can't be harmful, presumably.
Precisely. And Section 4.2 of the 2011 Act makes it clear. There's no presumption of public benefit anymore for any category.
Even poverty or education.
Not anymore. The Independent Schools Council case confirmed that for education, and Charity Commission VAG touched on it for poverty. The benefit has to be demonstrated. And you might even have to balance benefits against detriments, like in the National Anti-Vivisection Society case.
Which brings us squarely to stage 2, the public benefit requirement. This feels like where a lot of the complexity lies.
It often is. And the key rule here, for most charitable purposes, is that the benefit must be for the public or a sufficient section of it.
Most purposes. Is there an exception?
Yes, the big exception is trusts for the relief of poverty. Cases like Rees-Garisbrick and Dingle v. Turner confirm that poverty relief trusts can be charitable even if limited to, say, relatives or employees.
But for everything else, education, religion, etc.
For everything else, you need that public element. The benefit can't be restricted to a group defined by a personal nexus, a connection like blood relationship or contract.
And the key cases for that personal nexuses test.
Recompton from 1945 looked at blood ties.
Yeah.
But the really crucial one is Oppenheim v. Tobacco Securities Trust from 1951. That involved employees of a company. The House of Lords said that Link, the employment contract, created a personal nexus, so it wasn't a sufficient section of the public for an educational trust. That's a hugely important principle.
So even if it's a massive company with thousands of employees?
Even then, the Oppenheim principle holds that the quality of the link, contractual, matters more than the number of people.
The University of London material gives other examples too, showing how this plays out.
Yes, contrasting cases are helpful. Gilmore v. Coates, the closed order of nuns, no discernible public interaction, so no public benefit. But Neville Estates, providing a public place of worship that was presumed beneficial.
What about that Rekotkin case? Preference for employees.
That was a bit controversial. It allowed a preference for employees in an educational trust, which seems hard to square perfectly with Oppenheim. It's often criticized. Then you have cases like Williams Trustees and IRC v. Baddeley dealing with a class within a class where the group is too narrowly defined, even if large.
But geographical areas are usually okay.
Generally, yes. Benefiting the people of a specific town or county, like in Ree Lewis or Peggs v. Lamb, is usually seen as a sufficient section of the public.
And the big modern case, fee-charging schools.
Ah, yes, the Independent Schools Council v. Charity Commission case from 2011. Hugely important. It essentially said fee-charging schools can't just rely on providing education. They must show they provide benefit to the wider public, specifically ensuring the poor aren't entirely excluded just because of fees. It's about access.
So for public benefit study, definitely nail Oppenheim versus Dingle. Understand the ISC case implications, and practice spotting that personal nexus versus a genuine section of the public.
Absolutely. Get those distinctions clear.
Okay, next section in the material. Contaminating non-charitable elements. That sounds ominous.
It means things that can spoil an otherwise charitable trust. Big one. Politics.
Trusts can't be purely political.
Generally, no. If the main purpose is to change the law or government policy, that's usually not charitable. Bowman v. Secular Society and especially McGovern v. IRC are the key cases here.
Why is that?
It comes down to the court's role. They interpret the law, they don't decide if it should be changed, that's for Parliament. Also, it's hard for a court to judge if a political aim is truly for the public benefit.
But human rights trusts are okay now under the Act.
Yes, Section 3 includes advancement of human rights. There could be an overlap with politics, but promoting existing rights is seen differently from trying to change the law itself. It's a fine line sometimes.
What else can contaminate a trust? Profit.
Well, charities can make profits through trading, charging fees, as long as that profit is plowed back into the charitable purpose. But if the trust's main aim is making and distributing profits to individuals, then no, it won't be charitable.
And the trust has to be exclusively charitable.
Critically important. If the trust document allows trustees to spend funds on non-charitable purposes alongside the charitable ones, the whole thing can fail. McGovern v. AG again illustrates this.
Even if the non-charitable part is small.
Potentially, yes, though courts might interpret generously sometimes, Guild v. IRC, or allow spending on purely ancillary non-charitable things that directly support the main aim. And occasionally, they can sever the bad part, Salisbury v. Denton, but the core rule is exclusivity.
So, understanding why politics has excluded separation of powers, court's role is key here. Right, finally, the C-Pres doctrine. You mentioned this earlier. As near as possible.
That's the one. French for as near. Now, mainly covered by Section 62 and 67 of the 2011 Act, it's the mechanism the court uses when a valid charitable purpose fails, becomes impossible or impractical. The court can redirect the funds to another charitable purpose that's as close as possible, C-Pre, to the original intention.
But only if the trust was charitable to begin with.
Absolutely vital point. C-Pres only applies if the initial trust was validly charitable. If it wasn't charitable from the start, the property usually goes back to the settlor via a resulting trust. C-Pres doesn't rescue a non-charitable trust.
The University of London material distinguishes between initial and subsequent failure. Why does that matter?
It's crucial for how C-Pres works. Initial failure means the purpose was impossible, right from the moment the trust was supposed to start.
What happens then?
Usually the property results back to the donor, unless the court finds the donor had a wider, general charitable intention, an intent to give to charity generally, not just that specific failed purpose. Reimer and Refinger are good examples showing the court looking for that general intent.
And subsequent failure.
That's when the trust was up and running, validly charitable, but later becomes impossible or impractical. In that case, Section 62 says the funds are applied sepra to a similar purpose. Peggs v. Lamb is an example. The property doesn't go back to the donor.
What if the gift was to a specific charity that has now disappeared?
Yes, the material covers that too. It depends on interpreting the donor's intention. Did they mean only that specific institution? If so, it might be initial impossibility, needing general charitable intent. Reimer, Refinger again. Or is there a successor doing the same work? Roberts. Or maybe a successor doing different charitable work that still fits the donor's general aim? Farraker. It's about figuring out what the donor likely intended.
But C-Pres doesn't apply if the trust document itself says what happens on failure.
Correct. If there's a specific gift over clause, if this fails, give it to X instead, then that clause takes precedence over C-Pre.
Okay, so for studying C-Pres, definitely grasp initial versus subsequent failure and the huge importance of general charitable intention for initial failure. And pay attention to those defunct charity scenarios.
Those are the absolute essentials for C-Pre.
Great. The University of London material wraps up with study tips, which is perfect for our listeners. What are the main recommendations?
Well, first, really understand the core definitions and that two-stage test for charitable status. That's non-negotiable. Second, memorize the 13 heads from the 2011 Act and know how they relate back to PEMSL's 4 categories. Third, and this is massive, focus on the case law.
Knowing the facts and reasoning.
Exactly. Know the facts and the legal principle established in the key cases, PEMSL, Oppenheim, Dingle, ISC, McGovern, Reimer, Farraker, all the ones we've touched on. Be ready to apply those principles to new scenarios, like in an exam problem question.
And public benefit.
Definitely get a solid grip on the public benefit requirement and that personal nexuses test. Finally, the material suggests reviewing your course learning outcomes and, crucially, looking at past or sample exam questions to see how these topics actually get tested.
Excellent advice. So, wrapping up this deep dive based on the University of London's material, understanding charitable purpose trust really involves getting to grips with the definitions, that vital public benefit test, the ways trusts can fail, like involving politics, and then the Cypress mechanism for when things go wrong later.
It's a journey through those key stages, and the University of London resource is a great map for it. By focusing on those core principles and the big cases we've discussed, you, the learner, should feel much better equipped. Remember, this is all for educational purposes.
Absolutely. And this deep dive, it's really just a starting point, isn't it?
Definitely. The further reading list in the original document is your next step. If any particular area felt tricky or especially interesting, that's where you should focus your extra reading.
Yeah, dig deeper into what challenged you. Now, thinking about all this, the way the law supports charity, adapts with things like Cypress, balances public benefit, it leaves me with a final thought.
Ooh.
In our constantly changing world, with new challenges emerging all the time, how do we ensure that the legal framework for charity continues to effectively channel generosity towards the areas where it can make the most genuine public impact? How does the law keep pace?
That's a really fundamental question, isn't it?
Yeah.
How do we keep charity relevant and truly beneficial in the 21st century? Something for everyone to think about.